Hello everyone, hope you're all well. We really appreciate your patience. We're just going to do this video to give you a court update, the civil proceedings to do with the land dispute. Elizabeth's here with me and she's going to start with her notes and just give you a bit of an update to what's been going on. So,
hi everyone. Yes, this is a video update. It's about the hearing that took place, the most recent hearing in the civil case that's ongoing between us and Network Rail. This happened on the 3rd of April, which was Thursday this week. And just for the benefit of any newcomers to the channel, this is a civil action that we've brought against Network Rail concerning land ownership at Altnabreac, which is being heard at Wick Sheriff Court. Okay, the hearing that was scheduled on Thursday, it was called an options hearing. Again, for the benefit of people who don't know what that is, that's a hearing where both parties will make submissions to the court and the court will decide on the best way for the case to proceed. The hearing, there was a lot covered in this hearing. It was nearly an hour long. We're just going to go through the salient points of what was discussed in that hearing and the outcome of it. So just before that hearing, we lodged a motion to the court to ask them to do certain things. We asked the court to firstly extend what's called the period of adjustment to enable us to do the following things. Firstly, to arrange for our own surveyor to survey the extent of our solemn ownership and prepare a plan and report. Secondly, we asked the court to give us more time to arrange for our surveyor to survey the boundaries of the Notice of Title 1996 plan, which is the document that Network Rail is claiming to the court is proof of their good title to the land here. And we were also asking the court to give us more time to be able to adjust our pleadings to include what we consider to be the further wrongdoing by Network Rail last weekend between the 29th and 31st of March, where they've accessed our land and built on it without our permission. So that's what we were asking the court to do. And clearly it was our submission that the extra time needed would enable us to get the expert evidence that we require to support our case. And the court allowed that. The court allowed us further time and gave us the time that we asked for. We asked the court to give us a further 8 weeks and the court granted that. Okay, so we've been given that extra time to do what we asked the court to do. Also in that motion that we lodged to the court, we asked the court again for a third time. We reinstated our application to the court to grant interim orders and for people who from the UK or somewhere anywhere else other than Scotland, that's just the equivalent of a temporary injunction. So we reinstated our application for a third time for the court to grant an interim order to prevent and restrain Network Rail, its contractors, its agents and its tenant Scotrail from accessing our land, the driveway, and building and undertaking works upon the land that we claim is ours. That issue wasn't addressed by the sheriff, even though we did make that motion that wasn't addressed. So for the third time, we didn't get that interim order granted by the court, which was disappointing. Okay, a really important part of the hearing. I'm going to pass you over to Ian now, and he'll talk about what we talked about at length in the hearing, which was the established public right-of-way here at Altnabreac.
okay, so we talked in length about the access to the station, which is our driveway. The access is the public footpath that enters our registered title. Network Rail solicitors said that the public needed to access the station. She then went on to say that the public right-of-way is over the cattle grid, which is right in front of you, and then right onto the new path that has been installed here. A Network Rail solicitor wanted the court to make it clear what rights we have to restrict access to Network Rail, Scotrail, the public, and to the public right of way. That's correct, isn't it, Liz?
Yeah, that's what the submissions of the defender's solicitor was.
So we went on, we corrected the solicitor and told the sheriff that the correct route is through the pedestrian gate and straight along our driveway to the station. That is the historic established route. And that side pedestrian gate is what is in front of us right now to the right of the cattle grid. The sheriff said that he remembered me saying that we welcome the public back to Altnabreac. I agreed and said that we had never stopped them using the footpath. The sheriff asked what the footpath consisted of. So I went on to say that it's certainly not safe or suitable for pedestrians to cross a cattle grid, like Network Rail's solicitor suggested. Obviously, this cattle grid is not safe for men, women, or children on foot, or even animals, dogs, whatever. It's just not suitable to walk over that, and it's not safe. The sheriff thought that the pedestrian right of way was over the cattle grid, and because what Network Rail solicitor had said, isn't that correct, Liz?
That's what she told the court, and that was wrong.
But I explained to the sheriff that that was not the established public pedestrian footpath. The established public pedestrian footpath is through this gate here on the right hand side, which is to the right of the cattle grid, which Elizabeth is going to walk through. And if she's just going to carry on walking along the side of our drive, which is walking along the established pedestrian footpath. So I explained that to the sheriff, and we then went on to discuss that, you know, if there was no need for the new path to be used that was installed, because if that was used, it would be establishing a new public right of way to the station, which is not needed, and it's never been needed. We said that we had never had any issues with the driveway being used as the public right of way, and which is true. We've never prevented anyone from using the public access and right of way pedestrian footpath to the station, even though that is what was reported in the newspapers by Scotrail and Network Rail. It was untrue. I said that we'd rather use the established right of way rather than create a new one. Now the sheriff seemed to accept that. So then we went on to confirm with the sheriff once more that the established right of way was through the side gate along the track straight to the station, which is heading north from where we're stood right now. And the sheriff said, if we have no problem with that, then that's what would happen. That's the right of way, the pedestrian footpath that will be used. We said to the sheriff that Network Rail never needed to build the new path. It was absolutely pointless. Then Network Rail solicitor they expressed further concern that we prevented Network Rail and Scotrail using the public right of way in the past. So then the solicitor asked the sheriff to extend the pedestrian right of way to include Network Rail and Scotrail. I explained to the sheriff that the public right of way was not for commercial use, and he accepted that. We said we were willing to resolve that matter with Scotrail and Network Rail, and that's how we left that part of the conversation. The sheriff decided that only members of the public will use the pedestrian right of way to access the station. So we are pretty much back where we started when Scotrail and Network Rail decided to close the station, yet they are opening the station tomorrow. So the reason they closed the station was because they said Well, they said two things, didn't they, Liz? They said it was because of safety, and they said it's because of access, didn't they?
They couldn't access the station.
Yeah.
So again, just to clarify the legal position here, members of the public have never been prevented from exercising their right to use the pedestrian footpath to access the platform. That is because they have a legal right in law to use that route. That public right of way, like Ian's just explained and the sheriff accepted, does not extend to commercial workers. You cannot abuse a public right of way to be able to access land to undertake maintenance, building works or any commercial work. That would be taking the public right of way use. It'd just be outside the proper use of a public right of way, and the sheriff thankfully accepted that position.
Yeah.
So that's,
straight away.
Yeah, so that's why Network Rail and their tenant Scotrail have never been able, that's why they were prevented from using the pedestrian public right of way, because they didn't have a right in law to use it.
In all the years this station has been here, Network Rail and Scotrail have never had a right in law to access the station through here. So there we go, that's the update for you. Thank you very much for watching. Please like and subscribe. Any further updates, we'll get it together as soon as we can. Just to let you know, the next video that I will be uploading will be of when the BTP came here, and they didn't cut the chains this time. They actually jumped over the chains, and they told Scotrail to do the same. They gave permission to Scotrail to jump over our chains and access through the cattle grid, which has just been refused by the sheriff in Wick Sheriff Court. So again, once more, those BTP officers were acting unlawfully.
Trespassed on our land again.
Trespassed on our land again, and were threatening and abusive to us. We do have all of that recorded, just need to put it together, and I'll upload it soon for your consideration. Thank you very much. You take care. All the best.
Bye-bye, bye-bye. This gate here is our property. Let's have an impartial interaction.
Yeah, but since you've been there last time, Matt, okay, before you try and come in, you don't have permission to come onto our land.
Ian,
You don't have permission to come in.
these guys are going to
You do not have permission. Right, let's withdraw. Let's withdraw. Withdraw, Les. You're acting unlawfully again. This is a civil matter. Matt, last time you were here, you said to me that we didn't own this driveway, yeah? You said we didn't own this driveway last time. You acted unlawfully.